Hey out there, legal warriors. Is domestic violence a crime in and of itself in Washington state? That's a very confusing topic, and I'm going to set it straight for you coming up next. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington state for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people are going to get the help they need. I'm just going to jump right into it. This is a question I answer quite often here in my office, and I answered it today even. And people always say, hey, I can't get charged with domestic violence. And people tend to think that there's a crime in Washington state called domestic violence. And while that makes sense from how we talk about it, that's not actually the case. There is no crime in Washington state called domestic violence. There is no information, there's no criminal complaint that's called domestic violence. Domestic violence is what I call a designator that gets tacked on to other things that are actually crimes in Washington state. It designates the relationship between the alleged victim and the suspect or the defendant as a family or household member. So the most common thing we think about when we think about a domestic violence charge is assault in the fourth degree domestic violence. Assault in the fourth degree is any unwanted touching. If you come up on the street and push me and I'm not dating you and you're not married to me and we don't live together and you push me, well, that's assault in the fourth degree. Now, if my dad pushes me or my wife pushes me or my brother pushes me, then that's assault in the fourth degree domestic violence because the relationship between the person pushing me, that family or household member, fits in the category that defines the crime as a crime of domestic violence. So there is no charge that's just standalone domestic violence. It's a designator that gets tacked on. Now, the designator has consequences, and it changes what can happen in the case. But to make it a little more clear, there's no violence required in a domestic violence charge. Let me give you another example. Let's say that your boyfriend goes out of town and that you're really mad at your boyfriend and you decide you're going to steal your boyfriend's PlayStation or Xbox or whatever's popular nowadays. And your boyfriend's in Iowa when this happens. And he comes back and the PlayStation or the Xbox or something is missing, right? It's been stolen. So they call the police and then the police come and they talk to you and go, yeah, I stole it, so what? Well, they're going to charge you with the crime of theft, probably theft in the third degree, but they're going to call it theft in the third degree domestic violence, even though there was no violence. Your boyfriend didn't even know it was taken, right? There was no violence in taking this gaming system. But the designator that calls the relationship between the suspect and the victim is family or household member, and therefore now it's a crime of domestic violence. So it sort of seems unfair because it carries that violence term, even though when violence isn't necessarily involved, but that's the way our legislature wrote it. So what are the consequences? Why does it get charged as a domestic violence crime? Why would they even add that designator? Well, for non-felony cases, almost all cases have a maximum, not jail time, but jurisdiction of the court of only 2 years. If you get charged with theft, it's a 2-year jurisdiction for probation if you got convicted. For regular assault, it's 2 years, stuff like that. But any crime of domestic violence, if they tack on that designator, it gives the court up to 5 years of jurisdiction on somebody. So it gives the prosecutor more time to hold over a defendant's head to make sure they behave once the case is over. Additionally, as we're probably all aware, if there's a domestic violence designator, for many, many cases, it's going to make us lose our right to possess firearms if we're convicted of most crimes of domestic violence. Not all of them, and I've got videos that'll cover that, but the big ones like assault and harassment and things like that, we get convicted of a DV designator that's going to take our right to possess firearms. Additionally, if there's a domestic violence designator that's tacked on to a crime, now the court has the legal authority to actually issue a true no contact order, where if there's a violation of the no contact order, it's a new crime. There's no DV designator. The court can only set a condition of release. And a violation of a condition of release of no contact does not create a new crime. It creates a motion to revoke release and put someone in jail. In the current case, it doesn't create a new case. So that domestic violence designator does have consequences, but there is no charge that's just domestic violence. And so It could make a difference because how it looks in the public. What should your defense attorney do? If there's a domestic violence charge, well, they should try to negotiate it. They should try to get it dismissed if they can. They can try to go for a stipulated order of continuance. Some things they can't do on a domestic violence designator is they can't do a compromise of a misdemeanor. If you watch our other videos, a compromise of a misdemeanor is a law. I think it's RCW 10.99.020 if I remember, that says that if a victim say they've been civilly satisfied for their damages, let's say from the assault or from property damage, and they say they've been satisfied, then the defense attorney or the defendant can move to dismiss the case under a compromise. Well, the compromise statute says that crimes that have a domestic violence designator cannot be compromised. Additionally, DV charges can, work against us if we have school things we need to worry about. Sometimes there can be background checks where DV can be worse. And the prosecutor can remove a DV tag, but that doesn't always fully protect us because, of course, the arrest might still show a DV designator. It can get complicated, so talk to your attorney. The main thing I wanted to cover here is there is no crime that's just called domestic violence. You can't be charged with that. You have to be charged with an underlying crime, and then that's a designator that gets tacked on. Who else can it apply to? Roommates, someone that you dated 20 years in the past, right? Distant blood relatives now it can even apply to in the way it's being looked at. But they still have to prove the relationship, right? So if they got to prove a dating relationship and intimate relations, but they still have to prove it. So just because they charge it doesn't always mean they're right. So I hope you found that useful. If so, please like and subscribe. More people get to see it. More people get the help they need. And more importantly, if you have a criminal matter in Washington State, feel free to reach out to my firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.